Welcome back to the Office Talk podcast. Now, this is a super important episode, and I would encourage you to listen, especially if you run a business that is either based or has a presence in California, or if you hire workers based in California. Now, you may have been hearing all of the news about changes in the independent contractor test when it comes to classifying workers. And I have brought on my colleague, Jenny Wiegley. She has been a guest on our show in the past, and she is a labor and employment attorney here in the Bay Area. And I've brought her on to give us an update, to bring us up to speed on where all of these court cases and laws are heading and what that means for your business. So pop in those earbuds and let's have a listen. Hey, Jenny, thank you so much for joining us today to bring us all up to speed on all the different changes that are happening in California employment law.
Well, thank you so much for having me. I'm happy to be here.
Yeah, well, I wanted to bring you on because in the last, I would say probably what year or two, there have been a lot of changes in California specifically when it comes to how we classify workers, the whole independent contractor test and the employee test, like where we kind of put these people when we hire help for a business. And I work with a lot of folks, they're small business owners, often like a one woman, one man shop. And hiring can be very expensive for them, especially taking on, an employee. And so I wanted to talk to you about just any kind of guidance you have. Maybe we can talk through how the law has evolved over the last few years, and any guidance you might offer folks who are in that position who need the help. They want to hire the help, but they want to stay within the law, but they can't necessarily always afford to bring on a whole bunch of people on payroll and take on the expenses of, an employer-employee relationship. With that said, yeah, why don't you just kind of dive in and just bring us up to speed on what's been going on the last few years?
Yeah, absolutely. So we're right about at the 18-month anniversary of when this really important court case came down. The California Supreme Court decided a case that the nickname of it is Dynamex, because I'll be referring to it. And in the Dynamex case, they decided that they were going to reformulate the independent contractor test. And there had been a test in place since 1989 called the Burello Test. And under the Burello Test, really, you could be an independent contractor as long as the person you were working for didn't exercise too much control over what you were doing, and you bought your own materials and pretty much kind of how we always consider contractors, like, oh, okay, she's got her own laptop and she works from her home office and she sets her hours, therefore she's a contractor. But in Dynamex, they said that wasn't enough. And they developed this thing called the ABC test. And basically, it took those old elements from Burello and added to it that, the person needed to be performing work that was outside the usual course of the person who was hiring them's business, right? So if you ran a trucking company, you couldn't have a contractor driving a truck for you because trucking is your business. And obviously, this had a massive effect because most people hire contractors to do what their business does. They just don't want that person to be a full-on employee. They just need a little bit of help. Now, the rare exception is like, when you, let's say you're a restaurant and you hire someone to come in and paint your walls. Obviously, they're a contractor. You're not in the business of wall painting. You're a restaurant. But that's not what most California folks are using contractors for. That's the exception and not the rule. So Dynamex really turned everything upside down, and a lot of people were very freaked out, understandably, because this was such a huge change. And I got a lot of questions specifically about, and some of these came from your listeners, about salon owners renting out chair space to other stylists. And even if there was no money being exchanged other than the rent for the chair, under Dynamex, arguably they could be considered employees because they were performing salon services and the salon owner owned a salon, right?
Hmm.
Now, the good news is that they've now been carved out under this most recent law that I'll get into in a second, which is that, after Dynamex came down, people didn't really know what to do. A lot of people decided to just ignore it, because they didn't really know if it was going to get overruled, or, the court declined to go into too many specifics. So they thought maybe it won't apply to me after all. And some big employers, like the big gig economy employers like Uber and Lyft, just chose to ignore it. Probably that is what precipitated the state legislature deciding we don't just want this to be a court case. We want this to be an actual statutory law in California. And Governor Newsom just signed that bill, AB 5, into law last month, and it goes into effect on January 1st, 2020. And basically, it's just a codified, clarified version of the Dynamex rule. And when I say clarified, it does go into more of the details that the case doesn't go into. So it does carve out those people renting. It specifically carves out people renting space in salons, which leads me to believe that there was a powerful lobby in that industry because it's a very specific thing to carve out. It also carves out professionals like doctors, lawyers, and architects, which under federal law could always be contractors. But under California law, it was unclear. So now they're carved out. So those professions that have been carved out, and there's a list of them, and you can see it in the law, or just Google it if you're wondering if yours is on the list. But it's mostly professionals and people in very niche industries. Those folks are going to be subject to the old Burello factors, control and whether they're buying their own equipment, making their own schedule, that stuff. Everybody else is now indisputably covered by these Dynamex factors. And really, it doesn't change anything, right? I mean, the law on January 5th is going to be the same as it was a year and a half ago. It's just that there's a little bit more thrust behind it now that there's this law and it's all over the headlines and everybody's aware of it. Maybe they weren't aware of the court case, but they're definitely aware of this statute. So it's been all over the news. People are talking about it. And we already have heard from some of those big gig economy employers that they don't plan to comply. So that'll be interesting to see where that goes. I think the future of the gig economy itself is very uncertain now because it probably can't survive if they have to turn all of those workers into employees. But
and then they're talking about doing minimum wage down in LA of I think like $30 an hour for Uber and Lyft drivers. I don't know if have you heard that?
Yeah, and it would just be the business would fold because the profit model for those businesses is 100% based on the fact that they don't have any employee costs.
Yeah.
So, I mean, the unfortunate thing is that all of the people who have been delivering food or driving cars or whatever have had a nice side income. Instead of having their situation be improved by getting more wages, the jobs are just going to go away.
Yeah, because the cost is going to be transferred to the consumer. And
Exactly.
are you going to pay at a $30 an hour rate to get in an Uber? I mean, maybe we already do. I don't know if I've never calculated it. A 5-minute ride may cost you like $10, but
Right.
yeah.
For most of us, I mean, at least for me, if I'm going to pay the high premium, I'd rather be in a taxi where the person is licensed and I know that there are a lot of checks and balances in place for my safety, which is not necessarily true when it's just some random person in their own car, right?
Yeah.
So most of us take that risk because it's so much cheaper.
Yeah. And convenient.
Right. Yeah. Yeah. And like with DoorDash, I mean, it only costs me a few dollars to have someone bring me the Chinese food from a mile away. But if it costs me $20, I'm not going to do it.
Yeah. Yeah. Interesting.
So that whole industry is kind of in flux. But more importantly, I think, is the impact that this has on regular businesses who have been using independent contractors for budgetary financial reasons, not because their profits are dependent upon it, but because they maybe don't have the resources to have a full-on employee. And, you've got added expenses with an employee, right? You've got workers' compensation insurance, you've got payroll taxes, you've got to comply with whatever local paid sick leave laws there are. And like in San Francisco, those are extremely generous. It's 9 paid days per year. And you also have to comply with the many, many employment laws that protect employees in the state of California. So suddenly you're governed by these anti-discrimination laws that didn't actually apply when people are contractors. Not everyone knows that, but a lot of, the Fair Employment and Housing Act, which prevents employment discrimination, applies only to employers with 5 or more employees. But it's a big law to contend with. And there are all these other little tricky things, like you have to give them accurate pay stubs with specific information on it. And if you don't have like one line of info that the employee wouldn't even notice, I'm sure you're subject to these huge penalties. So it is really expensive to bring people on as employees. And especially here in the urban areas in California, in Silicon Valley and in LA, where you have a lot of small businesses and startup businesses, contractors are sort of the way to go in order to get people working without breaking the bank. Yeah.
And it's not even just the expense. I work with a lot of folks in the events industry, and they don't even have the demand to like bring somebody on full time, right? Because it's a very seasonal business where, they might be planning weddings only in like the summer months, let's just say. And so they're like, well, I don't need assistants, or I don't need assistant wedding planners or event planners like during the year. I just need it on the day of the event. And so they're kind of like, well, what do I do? Do I bring them on as employees? Do I just take the risk, hire them as contractors? Because sometimes even the people you're hiring would rather just be contractors.
Yeah. Yeah, often they would. It's less hassle for them, and they usually make more money.
Yeah.
And there are ways, I think, for getting around that. And, I'm advising people on this all the time because they've realized that they've got contractors who are doing work that's in their usual course of business. And there are a lot of different things that an employer can do in order to make someone an employee without necessarily breaking the bank. It takes a little bit of creativity because you have more options other than just bringing this person on as a full-time 40-hour-a-week employee, whether there's work for them to do or not, right?
Mm-hmm.
And I think that more and more employees or employers are going to have to be thinking in these terms when they know that they need someone to help out with something specific, and they're going to need to get paperwork in place for setting up these arrangements. And most people have an independent contractor agreement on hand, but it's going to be really important when either converting people to employee or hiring employees fresh off the bat that they have like an offer letter that sets out the terms.
Yeah. And this is something people ask me, like, do you have a template for this? And this is something, I don't know what your thoughts are on this. I will not create a template for this because I think it would hurt you more than would help you. Like, this is something that I would encourage you to work with a lawyer like Jenny or another labor and employment lawyer to work with you on, because it's not just like, oh, let me fill out this form. There's so much stuff that you need to understand as an employer that a lawyer can advise you on. And so this isn't something I would just be like, let me just find a template online and fill it in. I don't know if you feel differently.
Yeah. No, that's absolutely true. And there are a lot of customizations that you may or may not want that aren't necessarily legally required or legally mandatory, but you want them in there, and a template might not have them.
Exactly.
Right. So I agree. And the only time I will just hand off a template is if I'm working with a really savvy HR professional who knows what to do with it.
Yeah.
Otherwise, I do have a template, but it has a lot of sort of choose your own adventure caveats in it. And then I'll have the company fill it out, and then I'll go over it, and then we'll kind of solidify it.
Yeah. Well, you have the background to say, well, this is required. This is the stuff you can like not negotiate on, or like pull back on, or this is you can't remove this. So this is again something that I would really encourage people, because you also want to think about the potential risk, right? If this is one of those areas that if you don't get it right, it could potentially cost you a lot,
Yeah.
and it's not worth it. And so you might as well just do it right the first time around. Oh, go
The
ahead.
investment's not huge, right? I mean, it's usually something that can be done in an hour or two of an attorney's time. So it's not thousands of dollars. It's a few $100s typically, and then you're set, and you don't really need to review that offer letter unless and until it isn't working for you or some major change happens in the law, which is rare.
Yeah, that's a good point. Thanks for clarifying that, because I think people get overwhelmed with attorneys' fees and the costs of
Sure.
things. And so that's good to know that that may not even be the most expensive thing you have to do when you hire an employee. So for the people who are not in the exceptions, they're not hair salon owners or in the cosmetology field, and they're not under one of those exceptions, and they go through and they're like, I think this applies to me. Where do people go from there?
Yeah, I mean, that's a big question. And I think I always, as an employment lawyer, I always recommend that people get an employment lawyer to counsel them or an HR consultant. That can work too. And they're usually a little bit less expensive than attorneys. They're not cheap. And many of them are attorneys. They're just not practicing law anymore. They're just doing HR consulting. So that, someone like that, an attorney or a consultant can help you navigate this. But if that's really out of the question, what people really need to do is whether it's on their own or with a consultant, they need to decide, are they going to take the risky path or the less risky path? And so it really comes down to, am I going to comply with this law, or am I going to take my chances that I won't get caught? Because the only way that you get caught when you misclassify someone is if that person goes and alerts some kind of state agency that they were misclassified. And the way that that always happens, almost always, is that someone stops working for you and they go and they file for unemployment, not knowing that that's only available to a W-2 employee. And then the state gets that claim and they reach out and they ask you about this person, and you say, oh, they weren't an employee. And then they want to look at your books. And sometimes if you have a big business with a lot of contractors, you can end up with, just in back taxes, 6 figures of back taxes. That doesn't even get into the legal ramifications under the employment laws for misclassifying people. So that's how you get caught. Or maybe somebody calls the state and says, I was misclassified. But usually that's not how it is. It's usually pretty innocent.
Well, sometimes people are disgruntled, like that you might lay them off or something, or not lay them off, but stop working with them. And then there's just bad blood or something, and it just escalates. Yeah.
Yes. But definitely, even if someone leaves on the best of terms, they may just unknowingly rat you out by applying for unemployment. And that happens a lot. And so, but if that doesn't happen, if you don't get ratted out, the state will never know. So not that I'm advocating that people break the law. Obviously, I'm not. But I'm not inside businesses. If I'm not advising them and I'm not the one telling them they need to comply with the law, I can't stop people from doing what they're going to do, right? And so some people decide that they're going to take that chance. The downside to taking that chance is that it is a really, really expensive thing to get wrong. Sometimes when you violate certain employment laws, it's not a big deal. There's not a huge penalty associated with it. Misclassification is a really big deal because there are so many different laws that intersect for employees. And if you haven't been adhering to any of them because you've had someone classified as a contractor, they all come together and you're responsible under all of them. So you've got the back taxes, but you've also got the fact that you may not have been paying them overtime, and so you've got back overtime to pay under whatever minimum wage applies. And if it could be in a city where the minimum wage is quite high. And if you don't have records of the hours that someone worked, which usually you won't with a contractor, right? They work on a project basis. The employee is entitled to their best guess. If you don't have the records, their guess prevails.
Oh my gosh.
Yeah. So that's a big deal. And then you're also liable for the fact that you weren't giving them accurate pay statements because you weren't giving them pay statements. And they got their final paycheck late because they didn't get a final paycheck. And so all these things come together and it is massively expensive. I mean, companies have had to shut down for this. So, if people are considering taking that risk, they just need to know how big of a risk it is. Not that they'll get caught. That risk isn't huge, but the risk in terms of what it's going to cost them is quite large. And obviously, the more people they've had employed as contractors, the bigger the risk. Because if one person outs you as having misclassified someone, the state is going to come and find every single person you misclassified.
Yeah. You just don't want anybody sniffing around at all.
No,
Yeah.
you don't. I mean, you can be sailing along just fine for 10 years and then all of a sudden it comes in and they go back quite a few years in terms of liability. So it can be devastating. So that's why I say, I never recommend that anyone willfully misclassify.
Yeah, but I think like what I tell my clients, like I'm like, my job is to tell you what the law is and what you should do, but you're a business owner and your job is to assess like cost versus benefit, and like your risk tolerance and like
Exactly.
you decide what you do,
Yep.
And so I think that's what you're trying to get at here is like, hey, like this is what you should be doing, but not everybody, some people are willing to take that risk. Because of they weigh the kind of the cost versus benefit and they're like, I'll take the risk and I'll see what happens and I'll deal with it later. But that's in your court as a business owner.
Right.
um,
And I do have clients that even after I read them the riot act, they're like, okay, we hear you, but we're still going to do this. And that's their prerogative.
yeah, so I just want to be clear, maybe this is like a little bit of conflicts of law. So just for folks who are listening, so these all the stuff that we're talking about, that applies to California, so businesses based in California, operating in California, who hire California workers, correct?
Correct.
Okay, so but
Correct.
if I am I don't know, I'm just gonna say a wedding planner and I hire a virtual assistant in like Nebraska, the California laws, employee laws don't necessarily apply. It's the Nebraska laws that I need to comply with potentially.
Correct. That's most likely how it would be interpreted by the courts. You never know 100%. They might say, well, um, you know, we're going to make jurisdiction for all of this be in California for whatever reason. But generally speaking, the rule is that you're governed by the employment laws of the state in which you are performing services.
Okay, so that's important for people to know, both in
Yes.
terms of like, okay, well, just their hiring decisions, but also I have people who do hire people outside of the state and they think, oh, it's great. I have someone in Texas and Nebraska and Maine and whatever. I'm like, well, you have to comply with, like, you need to know what all those laws in those states say too, because they may
Yeah.
have different rules. I mean, California tends to usually be the kind of the oddball, I feel like, in all areas.
Yeah.
But, they're kind of the most extreme, but you still need to comply with the rules in all those different places where those employees or workers or contractors are based. So just something for people to keep in mind because in today's age, I feel like people are working with people all over the world.
Yeah, and most states have much more lenient independent contractor laws, more like what California used to have. When it becomes really important to know your state by state distinctions is when you do hire people on as employees, remote employees, because paid sick leave is something that dramatically varies from place to place, and leave laws vary from place to place. New York is trying really hard to compete with California for most complicated and employee friendly jurisdiction. So I always want people to be mindful of that. But yeah, in terms of contractors, I think it's at this point it's relatively safe to hire contractors especially in red states where there are far fewer employee friendly provisions and they're much more employer friendly. I mean, there are states in this country that literally don't have labor laws. They
Really?
just go by the federal labor laws.
Oh, okay.
Yeah.
Yeah.
Which are they are bare minimum. There's no meal breaks. Like there's really,
Wow.
really bare bones. So, and those tend to be the places where it's cheapest to get workers, but you don't have usually as big of a pool because workers tend to congregate in urban areas. So it all depends on where you find people. But yeah, definitely be mindful of where they're located. And if they're traveling to California to see you even a few times a year, you should probably treat them as a California employee
Okay.
or contractor. Yeah.
Okay. And then in terms of the IRS tests, then in this case, I mean, this is so much stronger than the kind of the IRS factors that they have.
Yes.
So if you're complying with the California rule, you're probably safe with the IRS rules. It's probably a fair statement to make, you think?
Yeah. Yeah, I
Okay.
think it is. Yeah.
Cool.
I want to say what people should do if they don't take the risk. Because I want people to know that they have some options other than just a 40-hour-a-week employee. And especially for people who have seasonal businesses or who work on a project base, you can absolutely hire someone to be an hourly employee, and there's no guaranteed number of hours you need to offer someone. You do need to comply with the hourly employment laws, which involve overtime, meal breaks, rest breaks, and it seems complicated, but once you get your head around it, it's not too bad. If you've got someone working for more than 6 straight hours, they need to get a meal break. If you've got someone working for more than 4 straight hours, they get a rest break. People get paid sick leave, etc. But you can lower their hourly rate a little bit to kind of compensate for these changes. And you can enter into an agreement with someone that says, when I need you and you're available, you're going to get paid X dollars per hour. You're also going to get, whatever benefits are accorded to you under state law. And then they can give further benefits if they want. But let's assume that money's tight and they just want to give the bare minimum. And then, they enter into that relationship and they use the person when they need them. And they pay them for whatever hours they work in a pay period. And maybe they don't work any hours in a pay period, so they don't get a paycheck. And then at the end of the year, they get a W-2 for all the hours that they worked. And so even though, you are having some additional expenses and there's a little bit more record keeping because you need those people to take very careful records of their time.
That was my next question. Yeah.
Yeah. And that's tricky, right? A lot of people, especially people who've been contractors, they don't want to do that, but once you get people into the habit and you make them understand that it is legally required, it's not that big of a deal. And there are software programs where they can just click when they clock in, click when they clock out. And some
Probably
of them
even on their phones, right?
Sure. I'm sure there are apps. Yeah. And that would directly communicate with the employer. People who use payroll services like Gusto, they have relationships with timekeeping software programs that will work with them. It'll be partnered. So the time will get directly sent to the payroll provider and the employer doesn't have to even worry about it. But that's usually a little bit expensive unless you have, 10 or more employees. So for people who only have a couple, it's really not necessary. And I also want people to remember that if they do have fewer than 5 people, there are all kinds of laws that they don't have to worry about. So it's not quite as onerous when you're just hiring a couple of people. There certainly are requirements, but there aren't nearly as many as when you have a lot of people. So,
but the new bill doesn't carve out an exception for people who have fewer than 5 employees.
Correct.
Okay.
Yeah, okay. It applies to everybody.
Okay. Yeah, because that was one of the questions. Like, someone was like, "Well, it's like an event day. Like, we work like 12-hour days. I can't be sitting there like, did you take your meal break? Did you take your rest break?" But I think to your point is if you can, especially if you can find some software, and I do think there are some that aren't too expensive where people can kind of clock in and clock out and take their breaks and keep those records. It's going to help you in the end, to kind of cover yourself. It's a little bit of upfront investment of time and resources to just kind of get all the paperwork sorted, set up payroll, but it's nice to know that they have this other option where they're not committed to a full-time employee, 40 hours a week.
Absolutely. And there are other arrangements that can be done too, where you pay someone minimum wage and then you arrange for them to get a percentage of whatever income is going to come in from a particular project, if that applies. And so you can set up a bonus plan. But that starts to get into more I need a lawyer territory. So I wouldn't recommend it for a shoestring operation, but for more sophisticated operations where you want to have the pay be tailored to the results more, there are options like that as well.
It's almost like on a commission, not a full commission basis, but
Yeah,
right. I'm thinking of
similar.
like car salesmen, right? Where sometimes they get a
Right,
base
right.
pay and then they'll get commission for every car they sell.
And commissions under California law have a million of their own requirements, but non-discretionary bonuses have fewer. So I often recommend those as a form of incentive compensation that isn't quite as onerous, especially if someone isn't just a straight up salesperson.
Okay. So much stuff. Oh my gosh,
Yeah,
this is so helpful. And I
I'm so
think
glad.
as we're kind of gearing into the new year, and I think people take this time to really think about their business and where it's going and where it's been, I think this is a really important conversation that people need to be having with either themselves or hopefully their lawyers, or their team or whatnot, to figure out as they move forward, how are they going to be structuring all of this in the future to protect themselves and also to protect their workers. So where can people get in touch with you if they want to work with you?
So I'm really easy to find through my law firm's website, which is maierlawgroup.com. And we're Maier. And you can email me, Jenny at maierlawgroup.com. And my phone number's on our website. So I'm always around.
Cool. So I'll definitely link that up in the show notes to your page so people can get in touch with you.
Awesome. Thank you.
Thank you, Jenny. And do you have anything to add?
I think people will be pleasantly surprised that it's not quite as onerous as it seems. It's just an adjustment. There's a mental leap to
Yeah.
kind of get over, but once you do, and once you're familiar with the requirements, it's not that bad.
Yeah, and I think what ends up happening is, a lot of people when they start businesses, they're looking around to see what other people are doing, and that they're like, well, that must be okay because XYZ person is doing this,
Yeah,
and so they think that's the norm, but
right.
especially when it comes to the law, like people just think, oh, I could do all these things because all these other famous people are doing it, but
Right,
not
exactly.
necessarily. Like to Jenny's point, there are people who knowingly are like, well, thanks for letting me know what the law is, but I'm not going to do that. I'm going to
Yep.
take a different course of action. So I think if you're really in this for the long haul and you want to do things right, it's important to work with people like Jenny, to get things, your ducks in a row, so to speak.
Yes, absolutely.
Well, thanks, Jenny, for making this all so easy for us.
My pleasure. Anytime.